Hello there, my dear friends. I am happy to bring you the final bar examination question, this time on procedural law and ethics, legal and judicial ethics. I have looked forward to this session considering that I have already loaded the three examinations. First, I loaded civil law and commercial law, and then I loaded labor law and taxation, six questions, and it ran for 30 minutes, and it went well. Then I went into political law, again complete. And I was very excited about criminal law. There are so many interesting issues that I raised there. Unfortunately, for some reason, and I'm not sure that that's with surface again this time, the microphone again was giving me some headache in that the audio was not very clear enough. I was able to watch some cell phone and iPad versions. Fortunately, they were dovetailing this somewhere in the bottom portion of the screen. So I guess many are still watching the suggested answers, and I hope that I am not giving you some little sleepless nights, because some of my answers are not the same as the others who ventured to put up their version ahead. In procedural law, actually remedial law, I was able to watch about six of the first questions, and I decided to really upload my version because I had some second thoughts about the answers that I was reading. I'm not saying it is wrong. Who knows, I can be wrong. But if you notice, I would never give an answer unless I double check the latest jurisprudence and also the caudal provisions. And so you will notice in my answers, while I don't read it because I did not want to give the impression I was impressing you. But should you want to validate my the basis of my answers, you will find them in something like it's a little brownish, something like this, and the letterings, the jurisprudence reference are in yellow, so you can see that. No, that's for the purpose of just in case there are any differences in opinion. I will not venture to give an opinion. I would rather give a suggested answer based on the latest jurisprudence that I can find available. And so, without much ado, we go now to remedial law, we used to call it, and then we go to legal ethics. They have a number of questions in legal ethics, three in legal ethics, very good questions. One of them is if you were to go abroad as a Filipino lawyer, and then you took your oath there and you became a foreigner, would you be able to come back to the Philippines and resume your being Filipino and also venture to again practice law? This was a question that was interesting. Candidly, I was not very sure also. I guess my gut feel is you may be allowed, but and that's exactly what was given to Attorney Dakanay, and we are citing his case here in the suggested answer. So without much ado, let us go through some of the breakdown of what they call procedural law and ethics, what we have come to know as our remedial law. And so in remedial law, we will tackle very interesting questions. Well, for those of you who are watching me for the first time, there is a little icon here for you to click so that you will be counted among my viewers, and that allows Google to give me a little allowance. I have not received any of my first pays, but they advised me there are already 3 checks that would be forthcoming somehow. I hope they come. Pambili man lang ng load, sa cellphone and also sa Zoom. So for those of you who've been watching me, you're familiar with this. For those of you who are watching me for the first time, after you click the viewership thing here, and if you want to go through this, just go ahead, feel free. The fields of academics, in the field of corporate management, and in the field of law where I'm coming from. And so now we proceed with the coverage of procedural law in the bar exams of February 6, 2022. The subject matter in the afternoon of February 6 covered 2 major fields, procedural law and legal and judicial ethics. In procedural law, it tried to cover almost the entire thing. It had questions on criminal procedure. It had questions on civil procedure. It did have some issues on evidence. It also covered special civil action. And very interestingly, they gave 3 questions on special proceedings. Now, in the area of what do you call this, legal ethics, they tried to give a question on legal ethics. There were 3, if I remember right. They have 1 in judicial ethics in terms of the conflict of interest of a judge having as a party litigant a cousin in front of him in the trial court. In legal forms they gave, and I appreciate that this was given, because definitely there is no lawyer who takes his oath and he handles his first case who will not encounter the matter of JURAT and the certification of non-forum shopping. So napakagaling isinama. Okay. And so without much ado, let's now go back to our main schedule. Tumawid kagad. Balikan natin. Masyadong napaaga kagad yung balik. And so I'd like to again proceed to this on procedural law. We'll look at criminal procedure as the first source of questions. In criminal procedure, ayan, there was a question on search warrant, and there was a question on qualifying circumstance in the information. Very, very interesting questions. So let's take a look at search warrant, a very critical thing, and I'd like to upload again the latest decisions of the Supreme Court on search warrant, because I have encountered a number of warrantless arrest cases, and I have ventured to file motion to quash before the trial courts. And so with this, let's take a look at search warrant. The question on search warrant, the question runs like this. A search warrant was issued authorizing the police to search for and seize a document that will show that the respondent is guilty of swindling and or estafa, B, copies of bounce checks, and C, all other relevant matters. Question: is the search warrant valid? Explain briefly. Our suggested answer: no, the search warrant is not valid. The documents and bounce checks are not described with particularity, most especially the mention of all other relevant matters. The Constitution demands definiteness on describing the things to be seized. So that's very important. The search warrant should observe the feature of being very particular about the documents to be seized, and also this Constitution requires the definiteness. And it's another way of expressing particularity. So that is on the search warrant question. On the question of the qualifying circumstance in the information, the question runs like this. In an information, a man was charged with having forcible carnal knowledge of a 16-year-old woman. The information did not contain any allegation concerning the victim's relationship with the accused. During the direct examination of the victim, the prosecution was able to elicit information that the accused was the 16-year-old woman's father. The defense counsel failed to object to the testimony, having also been surprised by the revelation. After trial, the judge convicted the accused of simple rape and imposed the corresponding penalty. The prosecution moved for reconsideration, claiming that the accused should be convicted of qualified rape and not simple rape because the relationship between the victim and the accused was proven, even as it had not been alleged in the information. Is the prosecution legally correct? Explain briefly. Our suggested answer: no, the prosecution is not legally correct. The qualifying aggravating circumstance of relationship must be alleged in the information for conviction of qualified theft. Continuing now. These are explanatory notes which may or may not be included by the bar examinee in his answer. The information shall allege the qualifying circumstance so that the accused is informed of his constitutional right to know the nature and cause of the accusation against him. The purpose is to allow the accused to prepare for his defense to prevent surprises during the trial. The qualifying circumstance not pleaded but proved shall be only as aggravating circumstance. It is denial of due process when the accused is charged with simple rape and convicted of its qualified form. And you will notice here that there are certain citations given. The case of People versus Aquino, a 2002 decision, and People versus De Guzman, a more recent 2019 decision. And so that essentially is your criminal procedure. Now, we go to its sister topic, which is civil procedure. And in civil procedure, very interesting, the bar examination did give 4 questions in civil procedure. One on persons, the other one is on forum shopping, very interesting question on forum shopping. And then judgment and execution, this I had to do a little research, and then the appeal. Okay. So let's go now to the first question in civil procedure, persons as parties. This one, nakakapuwing yung tanong. And I smiled when I saw it. It says, can dolphins be plaintiffs in a suit to enjoin a land reclamation that will affect a biodiverse coral reef? Explain briefly. Well, the answer is no. Dolphins cannot be plaintiffs in a suit. Only natural or juridical persons or entities authorized by law may be parties in a civil action. Very straightforward under Section 1, Rule 3 of the rules on civil procedure. The second question in civil procedure is on forum shopping, and it runs like this. A party through counsel filed a complaint to nullify the extrajudicial foreclosure of mortgage done by a creditor bank. The bank had already filed its answer. However, the counsel for the plaintiff felt that the judge was partial to the defendant's counsel. Wanting to bolster the chances of winning for their client, the counsel for the plaintiff filed a second case against the same bank, seeking to nullify the same extrajudicial foreclosure, but this time adding a prayer for the award of damages. The second case was referred to another judge. The defendant bank's counsel then moved to dismiss the second case. Will the motion prosper? Explain briefly. Our suggested answer? Yes, the defendant bank's motion to dismiss the second case will prosper. The plaintiff filed the second case with the same cause of action and with the same prayer, even when the previous case has not been resolved. There is identity of parties, rights or causes of action, and relief sought, creating the possibility of two separate and conflicting decisions. This was highlighted in the case of Zamora versus Kinan, a 2017 decision. A question on judgment and execution. The question reads, on her deathbed, your grandmother revealed to you that in 1994, she and her family won a civil action for damages against a former president for human rights atrocities committed against them during martial law. The judgment was never appealed. Your grandmother informed you that she never had the judgment executed because she wanted this to be her parting gift for you when she passed. She said that she also felt the need to wait for one of her grandchildren to become a lawyer. It so happened that you have just passed the Pound Best Bar Ever 2020_2021. Your grandmother spent her last moments narrating how she had been arrested by the military during martial law and was then tortured and raped while under detention. She emphasized that her case was not unique and that until now, she was yet to receive an apology from any member of the former president's family. With her last breath, she instructed you not to let her experience happen again. Her parting words to you were, never again. Is an action for revival of judgment the proper remedy to enable the judgment's execution? Explain briefly. Our suggested answer? No. An action for revival of judgment prescribes in 10 years, after which the execution of judgment can no longer be done. So that is supposed to be 1994 plus 10, that's about 2004. On the first 5 years after the judgment has become final, the execution of judgment can be done by motion. For the second 5 years, there is a need to file a civil case to revive the final judgment. After the lapse of 10 years, the claim is prescribed under the statute of limitations in the civil code. So, sorry na lang Lola, the case can no longer be initiated by your apo who has become a lawyer. And finally, the fourth question on civil procedure is appeal. Question, and this was question number 2. The last day of a losing party to file a notice of appeal from the Regional Trial Court to the Court of Appeals fell on June 12, a legal holiday. The day after, or on June 13, the counsel for the losing party moved that the period within which to file a notice of appeal be extended for 10 days, citing the counsel's humongous caseload among others. On June 23, that same year, without the motion for extension being acted upon, the counsel for the losing party filed a notice of appeal. Should this appeal be dismissed? Explain your answer. Now, before we go to our suggested answers, just take note that the last day for filing the appeal happened to be June 12. And we know June 12 is a legal holiday. So on June 13, that was when, he filed his motion. He did not file his appeal, but he filed this motion to extend, the appeal period by another 10 days. And so he says, on the 13th plus 10 is 23. So on the 23rd now, he filed a motion, a notice of appeal. Now, should he succeed in this particular thing? This is a very interesting procedural question, and you should, when you become a lawyer, you should take extra precaution on this possibility. Unang-una June 12 holiday. Ba't hindi mo final, a few days before June 12, no? Okay, and so, here is the suggested answer. Yes, the appeal should be dismissed because the same should have been filed on June 13, the day after the June 12 deadline, which fell on a holiday. Kumbaga sa deadline noon 12, okay, pa-consuelo, hindi mo pwedeng i-file. At least man na i-file mo noong June 13. No? Hindi mo final ng June 13, wala na, maglalapse na yon. The motion for the 10-day extension should have been filed earlier before the June 12 deadline. Kasi technically, kung final mo ng June 13, wala na, expired na, and you cannot, you cannot go for extension of something that is no longer there. When the 10-day extension is granted, assuming na-grant, and filed before June 13, the deadline is June 22. So the counting would still be on June 12, not on June 13. No? June 12 yung holiday. Lalagyan mo ng 10 days yun, no? And so when the 10-day extension is granted, the deadline is June 22 because the extended period starts on the initial deadline of June 12 and not the day after. Very, very important input. And this was decided bagong-bago lang, 2013 in the case of Rainier Pacific International Shipping versus Guevara. And also specified in the Supreme Court, there is this administrative matter under Section 1, Rule 22 of the Rules of Court. Okay. So that essentially covers the 4 questions raised on civil procedure. Tingnan natin kung may tinanong sa evidence, no? Meron tinanong sa evidence under the revised rules, and the question had something to do with what you call this sa ko bilalagay ito dito. Ang question had something to do with photographs as documents, no? Mamaya titingnan din natin yung civil action, special civil action, yung unang tinanong, which is a question on Mandamus. Dito muna tayo sa evidence where it's asking about photographs. The question on evidence is the printout of a photograph from your mobile phone showing a fly, langaw, in the soup you ordered admissible in evidence in an action for damages against the restaurant owner? Explain briefly. Our suggested answer: yes. The printout of a photograph is admissible as documentary evidence when shown, presented, or displayed to the court. The person who made the recording shall identify, explain, or authenticate said photograph. Ganun lang. So kinlik, pinrint, present yun as documentary evidence. But the person who took the picture, and who developed it, will be presented as a witness on the witness stand to explain how the photograph came about. Very basic. And now, the next question would have something to do with special civil action, and what was asked was Mandamus. Okay, let's take a look at what the question on Mandamus was all about. The question: will a petition for Mandamus lie to compel the Secretary of Foreign Affairs to convene representatives of neighboring countries similarly situated with the Philippines in order for them to find diplomatic solutions to enforce the arbitral award relating to the West Philippine Sea? Explain briefly. Our suggested answer: no, the petition will not prosper because Mandamus cannot compel the Secretary of Foreign Affairs to perform a discretionary power on diplomatic relations. Discretion is a power or right conferred by law upon an official acting officially under certain circumstances according to the dictates of his own judgment and conscience, uncontrolled by the judgments or consciences of others. Mandamus will not control the exercise of discretion. If you will notice, there is an old case, Sanson versus Sanson, as early as 1936 where this was resolved. No? And there was a similar question number 11 in the in political law given just a few days before this was given. So merong konting overlap. And those who know the answer would have credit for two questions that were asked and accordingly answered. Okay. And we now go into special proceedings. There were three very interesting questions on special proceedings. And somehow this should have been anticipated, no? The first question had something to do with habeas corpus. At ito nakakapuwing, nakakapuwing. On habeas corpus, the question that was raised was inspired by the movie On the Job. The superintendent of the new Bilibid prison, without any court order, transferred 10 persons deprived of liberty to an agricultural farm in Davao del Norte to plant kamote. The owner of the agricultural farm promised to ensure that the persons deprived of liberty would not escape and would always wear the proper uniforms. Two of these 10 persons deprived of liberty found a way to approach you and suggested that you file a petition for the writ of habeas corpus on their behalf. The persons deprived of liberty added that they had no family in Davao and that their families had no means to visit them there. Is a petition for the writ of habeas corpus the proper remedy for their case? Explain briefly. Our suggested answer: no, the writ of habeas corpus does not apply to a convicted criminal because his detention was made by order of the court. Habeas corpus is to ensure a fair trial before a court of law for a person under detention before conviction. So kaya binibigyan na habeas corpus para yung nakakulong na wala pa namang conviction, ipatawag para nga mabigyan ng due process of law. May kasalanan ba o wala, So that is the function of habeas corpus. Pero pag nahatulan na, ang nag-utos na ikulong yung korte. And so the court cannot issue a writ of habeas corpus to order the appearance of a convicted prisoner dahil sila na nga ang nagpakulong dun sa convicted prisoner na yun. So habeas corpus does not apply. Very interesting point of view. The second question is its cousin, habeas data. Let's take a look. The question on habeas data runs like this. A spokesperson of a special unit of the Armed Forces of the Philippines announced in a television interview that the Armed Forces was putting all progressive and left-leaning party list representatives under surveillance for alleged links to the ongoing insurgency. An outspoken and progressive party list representative approaches you for advice on how to discover the information that the armed forces may have collated through the surveillance operations. Will a petition for the writ of habeas data be the proper remedy? Explain briefly. The answer is yes. A petition for the writ of habeas data is the proper remedy when the party list representatives can show their need for protection against threats and harassments by the military, arising from the gathering and use of data from the surveillance, precisely as a consequence of said data gathering. You know, when I was thinking about this, it dawned on me that on the fundamental structure of human rights, which is embodied among others in our Bill of Rights. The purpose of the Bill of Rights, and the protection of human rights, is to ensure that the members of the sovereign people, in their individual and collective capacities, do not suffer grave abuse, even to the extent of torture and threats from the very government that they created, especially its implementing arm, the military and the police force. On the other hand, having said that, in that the intention of the Bill of Rights is to protect these people, the very system of government is also supposed to be protected by the very same people. Sila nga nag-organize ng gobyernong yun, they should be interested to equally protect that form of government. And they delegated that to the government, and it is executed by the Armed Forces of the Philippines and the Philippine National Police. So let us put in mind the regularity in the performance of duty of the government, particularly the armed forces, our soldiers, and our police officers. They are not doing those things, including yung surveillance dito, and probably the arrest of those who will go against armed revolution against the government, if they are not equally interested to protect the very government that these people created. The people created their government. And so that therefore, it is to their interest that they protect this government. Kaya nga, dinefine nga nila sa Constitution ano yung gobyernong yun. So when the police force and the military organization performs their jobs, it is really to equally protect the people by preserving the government that they deserve. Ang reconciliation lang nito is when they perform their jobs in behalf of the people, they should equally not abuse the people. Kasi in their earnestness, hindi naman natin sasabihin gusto nila na gawin yun para lang sa katuwaan o kursunada nila. Hindi, they have a mission. And the mission is also to protect the people. Kaya lang, in the process of protecting the people, pwedeng magkaroon ng overkill, pwedeng magkaroon ng abuso. And so the people now would invoke their human rights under the Bill of Rights and say, "Hoy, napapasobra ka naman yata." And so there is where the check and balance comes in. Ngayon, dito sa writ of habeas data, nagsa-surveillance. Is the surveillance per se objectionable? The answer is no. This is intended to protect the very government of the people that they organize. Kaya nagsa-surveillance nga, defensive mechanism yan. Pero out of the surveillance, they're able to gather data. And if this data are abused, in order to hurt people, by creating threats and harassment against them in their individual capacities, then these people now will say, oy, sumosobra na yata yan. It is not the surveillance. It is not the data per se. It is the consequent use of threat and harassment arising from the data gathered. So, kung nagagamit na yung data na yun, yun ang gagawin ngayon ng magpapile ngayon, no? Those who are aggrieved, they will now go to court and file a petition for writ of habeas data. Ngayon, pag nakaharap na yun sa korte, sasabihin na nila, ginagamit ho yan para takutin kami, para abusuhin kami. Kami naman ho nagsasalita lang ng aming karapatan. They are threatening us. So, we question now na yung mga ginagamit na data na yan na ginagather, dapat ho siguro tingnan kung proper yan. Is that serving the need to protect the people and their government against, of course, those who would like to overthrow them. Yun ang reconciliation ng writ of habeas data in relation to possible abuses, no, by the military versus naman the mission of the military to protect the very government that their very own people created. Ang ganda-ganda po ng reconciliation. As you know, the writ of habeas data is relatively new, and this will continue to what we call this, populate our legal views as it goes to be implemented by our military and the police organizations. And as our people in turn perceive probably abuses that is in the form of threats and harassment. The third special proceedings is another very interesting and related, the writ of amparo. Ito naka-enshrine dito si retired Justice Adolf Ascuna kasi when he was the chairman of the bar examination panel, yan ang first question na binigay sa political law, the first subject, describe the writ of amparo. Okay. I remember the first time I heard about the writ of amparo, sabi niya, if it is the Supreme Court that is abusing your right when you have no other recourse, then the writ of amparo is available. Yan. It gave me the impression that pag wala ka na talaga magawa, inaabuso ka na, writ of amparo is your final what we call this fallback position. Tingnan natin yung question dito sa bar na ito on the writ of amparo. The question runs, upon learning of her husband's death, the wife and their daughter went to a funeral parlor, but the husband's remains lay. The husband had been killed in a military encounter in the hinterlands. He had been suspected as one of the members of an insurgent group which had been yearning for the violent overthrow of the status quo for more than 50 years. Upon arriving at the funeral parlor, the wife and the daughter found that the premises were guarded by heavily armed individuals clad in military uniform. These individuals accosted the wife and the daughter when they attempted to approach the husband's casket. The two were then interrogated for almost an hour. Fearing for their lives, the wife and the daughter hurriedly left after the interrogation. On their way home, they noticed a red car following them. The same car, which carried individuals sporting crew cuts, parked in front of their home for several days. The daughter noted the car's license plate and called the local police for assistance. The local police simply laughed at her, saying that they should just cooperate with the military and reveal all that they knew, or they would also suffer the same fate as her father. Will a petition for the writ of amparo prosper for the wife and the daughter? Explain briefly. Our suggested answer. Yan. Ibababa ng konti natin ito para makita nyo naman. Pero dito muna. Our suggested answer. Yes, the petition for the writ of amparo can prosper because the wife and daughter of the killed suspected insurgent need protection from the threats and harassment of the military personnel, with said acts being violative of the right to life, liberty, and security. And this is supported by a decided case of the Supreme Court, which is the National Union of People's Lawyers versus President Duterte himself, a case that was decided by the Supreme Court on 3 May 2019. So, bagong-bago ito. So, pagka medyo hinaharas ka na, yun nga sabi nga ni Justice Ascuna, pag wala ka nang magawa, no, wala ka nang takbuhan, then you go to the Supreme Court to file a writ of amparo. May mga ano na yan, may mga baris ano na yan, no, there is this kind of protective order and so on, you know. Okay. So that is the answer to our writ of amparo. That finishes our procedural law. And so we are now ready to move on to the question on ethics, both legal ethics and judicial ethics, as well as the legal forms. On the legal ethics, there were 3 questions. No? The question on the lawyer's privileged communication, an issue on the client's funds, and yun na nga yung kanina pinag-uusapan natin at the start na we will have an opportunity to visit now, yung resumption of law practice by a Filipino. He became a foreigner and took back his oath of allegiance to the Philippines. Then, the only question on judicial ethics is the presence of a relative before the judge who is trying the case. And finally, JURAT and non-forum shopping. So, tingnan natin ang privileged communication. On the question of privileged communication, while attending a wedding, a lawyer got to dance with and talk to another guest who ended up sharing details of their marital problems. When asked by the guest, the lawyer explained the distinctions among legal separation, annulment, declaration of nullity, and divorce. The lawyer went on to not only extend advice but even to map out a strategy on how the guest's marital woes could be addressed. At the end of the conversation, the lawyer and the guest agreed to meet at a later time to continue their discussion. After the dance, the lawyer returned to their seat and shared with their best friend the guest's marital problems. Did the lawyer attorney-client privilege? Or did the lawyer breach attorney-client privilege? Explain briefly. My suggested answer, yes. The lawyer breached the attorney-client privilege. A lawyer shall preserve the secrets of his client, acquired confidentially in a lawyer-client relationship, except when the client authorizes him to make the revelation. A lawyer avoids indiscreet conversation about his client's affairs. Now, this is indeed very interesting because they were having a party and then while they were dancing, you know, bati-bati na, naikwento nung isang babae yung kanyang problema na marital. So, nagka-discussion na sila nung abogado and the lawyer was starting to somehow perform his function as a lawyer by giving already some inputs that he learned as a lawyer, you know. And then there was already an opportunity na there may be an evolving client engagement by of the lawyer, no. Ang problema, pagbalik niya, nagkwento siya kaagad doon sa marital problem nung babae, no. You know, if there is a gray area here whether there was a client attorney relationship, basta nagsimula ka na makipagkwentuhan tungkol sa batas, there is already an engagement, whether it's paid or not paid, whether it will continue to be a formal arrangement or not. Meron na kagad for purposes of privileged communication a client-attorney relationship. I will always be reminded that the privileged communication of a lawyer can be put side by side with the confidentiality of the confessional. Ikaw ba naman, pupunta ka ron sa pare, sa confessional, sasabihin mo, pare, Father, bless me for I have sinned since my last confession, I've committed the following sins. Father, ganito ang kasalanan ko. Father, ganito, ganito, ganito. Will you be able to open up to the priest kung alam mo paglabas ng pare, pag nagkwentuhan sila ng kapwa niya pare, o kaya yung mga parishioner, oy, si Brother Joe pala ganun, ganito, ganun, ganito. You cannot do. So that's why when you want to test the privileged communication of a lawyer, you should always put the lawyer in the same footing as a priest in the confessional. He should shut his mouth, And dito binigyan naman, unless nga the client would allow. Pero normally, he is not authorized to talk about anything that he learned when talking to somebody at pinasok na yung batas. Once the lawyer starts explaining, like in this case, pinapaliwanag na niya yung legal separation, annulment, declaration of nullity, and divorce, family code na yan, that may lead to what? A case of either annulment of marriage, legal separation, yung mga ganon. Meron ng engagement yan. So he should shut his mouth insofar as what he learns from the client is concerned. That is all also for self-preservation natin mga abogado Because if some lawyers should talk about what they learned from the client, most clients will believe na lahat ng abogado chismoso. Pwede nga mangyari yun. Huwag naman natin gawin na matakot sa atin ng ating mga potential clients na hindi pwede tayong pagkatiwalaan. That's the rule on privileged communication. The second topic on legal ethics is on the client's funds. Let's take a look at what happened here. Okay. The question runs like this. During work, an overseas Filipino seafarer was seriously injured after falling into the elevator shaft of a foreign vessel. After initial treatment in Singapore, the seafarer was flown to the Philippines to continue medical treatment. While the seafarer was confined in a hospital, two paralegals representing a lawyer approached the seafarer offering that lawyer services at a significantly discounted rate. They explained that they could sue the employer for indemnity and added that the lawyer had a good track record at the National Labor Relations Commission. The paralegals even bragged about the lawyer's connections at the Supreme Court. The seafarer agreed to engage the lawyer's services. The employer proposed to settle the case out of court and eventually paid 5 million pesos. The employer deposited this amount in the lawyer's bank account. The lawyer tried to remit 1 million to the seafarer, making it appear that the settlement was only for that amount. The seafarer refused to accept the amount of 1 million as no prior approval had been given to the lawyer to settle the case. The seafarer filed the complaint before the Supreme Court for the lawyer's disbarment. Does this seafarer have legal grounds to file the complaint? Explain briefly. Let's take a look at our suggested answer. Our suggested answer is yes, the seafarer has legal grounds to file a complaint against the lawyer for disbarment. A lawyer shall account, and did not in this particular case, for all money collected or received for the client. A lawyer did not deliver the funds and property of his client when due, and this is in accordance with Rule 1602 and 1603 of Canon 16 of the Code of Professional Responsibility of 1988. Ayan, yan ang importante. Kahit na kailangan natin ng pera, bilang mga economic individuals who need to survive, wag naman natin gagalawin yung pera ng ating kliyente. 5 million yung binayad, no? I-declare natin 1 million, bubunta natin ng 4 million. Sabihin mo na kung pwedeng mangyari na 5 million ang binayad. Magkano bang gusto mong ibigay sa akin? Attorney, magkano ho ba ang kailangan nyo? Pwede bang yung 1 million sa'yo, 4 million sa akin? Pumayag, wala na ngayon case of disbarment, except siguro pwedeng magkaroon ng issue ng quantum merit issue na napasobra naman yung mas malaki pagkinita ng abogado kaya sa client. But if the client did not disagree on that one, wala namang problema eh. But you should remember, yung 15% continued success fee is almost like standard guideline for us to charge on attorney's fees on a contingency base, on a what you call contingent success fee basis. Okay? Next, resumption of law practice. Yan, tingnan natin. The problem reads, a known tax lawyer in Iloilo became a member of the Integrated Bar of the Philippines in 1974. The lawyer later migrated to the United States and became an American citizen in 1989. In 2006, the lawyer reacquired their Philippine citizenship by taking the oath of allegiance as a Filipino citizen before the Philippine consulate in Washington, D.C. in the United States. The lawyer now intends to return to Iloilo and resume legal practice. Can this lawyer continue to practice law in the Philippines? Explain your answer. Our suggested answer: yes, the Supreme Court may grant that the Filipino lawyer who reacquires Filipino citizenship pursuant to Republic Act 9225 resumes his law practice when, under 4 conditions. A. He updates and pays in full of the annual IBP membership dues. Naku, cumulative yun. Letter B. He pays his professional tax. No? Ito current lang naman yan. Letter C. He completes at least 36 credit hours of mandatory continuing legal education to refresh his knowledge of Philippine laws and update him of legal developments. Yan, napaka-importante para hindi naman luma yung alam niya. And letter D, he retakes the lawyer's oath. I like this, He retakes the lawyer's oath to remind him of his duties and responsibilities as a lawyer and as an officer of the court, with his pledge to maintain allegiance to the Republic of the Philippines. Yan po ang decision in the case of Attorney Benjamin M. Dacanay, which was decided by the Supreme Court in 2007. And bank pa yan. No? Binalik siya in his practicing law and was able to start practicing law. Those are the 3 questions on legal ethics, and there is only 1 question on judicial ethics, and this is on the judge's conflict of interest. Let's take a look. The problem reads, and this is number 15 on the bar. The lawyer of an accused filed a motion to inhibit, alleging as ground that the judge was the cousin of the private complainant, which is within the 4th degree of consanguinity. Should the judge inhibit? Explain briefly. Our suggested answer: yes. The judge shall inhibit himself. Judges shall not participate in the determination of a case in which any member of their family represents a litigant or is associated in any manner with the case. Judge's family includes the judge's spouse, son, daughter, son-in-law, daughter-in-law, and any other relative by consanguinity or affinity within the 6th civil degree, or person who is a companion or employee of the judge and who lives, take note of that, and who lives in the judge's household. No? So this was decided, you notice that in the case of anonymous complaint against presiding judge Anali C. Aldea Arocena, Municipal Trial Court Judge in San Jose, Nueva Ecija. This is very recent, a 2019 decision of the Supreme Court. No? Okay, so ito ang sinasabi rito do sa una 4th degree lang, dito allowed 6th degree, no, second cousin. Okay, so dapat mag-inhibit yung judge voluntarily. Now let's go to the 2 legal forms that were asked. No, The first one is on the JURAT. Ito po napaka-importante para sa ating mga abogado. At the end of our pleadings, no, we prepare a JURAT. Ayan, no? Palagay, Republic of the Philippines, the place, Parañaque City, Metro Manila, SS, and it reads, subscribed and sent to before me the 17th February 2022 by John Darrell F. Arguesa, who exhibited to me his LTO-issued driver's license number CGP 101467, issued at Quezon City, Metro Manila, Philippines on 17th October 2020. And you put your signature, very important. You indicate notary public, your Supreme Court roll number, your IBP lifetime membership or your current membership, and then your MCLE exemption and your PTR number, which is the current one for the current year. So that is tapos yung usual reference, document number, page number, book number, and series of 2022. So that is how a JURAT would look like. The last question for the entire 2022 bar examination is a question on certification of non-forum shopping. Yan, very important. Hindi pwedeng pahabol yan. Dapat kasama ka agad pag final yung complaint. So it's a reading certification of non-forum shopping ay John Darrell F. Arguesa of legal age, single, a Filipino citizen, and a resident of number 38 King James Street, Kings Point Subdivision, Barangay Bagbag, Novaliches, Quezon City. After having been sworn in accordance with law, depose and say, the first one, that I am the respondent in the above entitled case, having caused this counter affidavit with counter charge to be prepared. That I have not commenced any action or proceeding involving the same issue and specifically the same checks in the Supreme Court, the Court of Appeals, or any other tribunal or agency, particularly before the office of the City Prosecutor of Manila. And number 3, that to the best of my knowledge, no such action or proceeding is pending in the Supreme Court, the Court of Appeals, or any other tribunal or agency, and that if I should learn thereafter that a similar action or proceeding has been filed or is pending before this court or tribunal or agency, I undertake to report that fact to the court within 5 days therefrom. Assuming that there is one that you have to disclose, then you can mention here, no, that I have not commenced any action or proceeding involving the same issue and speaking the same in the court, particularly. However, then you can make mention now. I have executed, say if this is a case of, for example, homicide, and you have a counter charge of serious serious physical injuries, then you mention it here. And what is the nature of the case, what is the reference of it one, where was it filed, and where is it pending. Ganon din dito sa paragraph number 3. Okay. So, ladies and gentlemen, this is our certification for non-forum shopping, and that is the coverage on legal ethics. This is our essential coverage in procedural law or remedial law. We have covered criminal procedure, civil procedure, ito yata 2, dito 4, that makes 6, isa rito 7, 3 sa special proceedings 10, and then 11, no, special civil action, no. And so I guess this is our final sharing for the bar 2022, and this is the most awaited subject matter. As you know, historically, the mortality even among those who are full-time students, even among the 4 leading law schools, is remedial law. And somewhere along the line, the examination that was given now on procedural law and ethics would be reasonable but not easy. It is not easy. I would submit that the questions would still have required a good law student to have studied well when he took the bar examination. Pero hindi naman imposible, no? It is not something that you will not pass because the intention is first level, entry level for lawyers. So I'd like to again reiterate my congratulations and sincere appreciation to Associate Justice Marvic Leonen for being chairman of the Bar examination for the year 2021-22, no? Na-postpone niya ng 2 beses, natuloy din, no? And as again, I reiterate na he was the first one to venture into creating examination centers all over the Philippines rather than focusing it here only in Metro Manila for the past few years at the University of Santo Tomas. This is helping a lot of our law students in the provinces, to have a shorter and cheaper means of transportation. The more aggressive one is to introduce now computer systems, and there have not been any feedback that nagkaroon ng computer or technological bottleneck. Wala, tuloy-tuloy. I would expect that the correction would also, kahit na marami, 11,000 yun. Dati, 7 to 8,000 ngayon, 11,000. Dahil na-combine yung 2 years Pero with soft copies being consolidated now, it may be easy to correct it. No? Mga keywords lang yan. Pag nakita na, correct na. And so, I'd like to thank you very much, my dear fellow future lawyers who are viewing this, and also for all of our law students who may want to learn from this 2 days 4-subject examination. And I hope that they continue with this one. Hindi naman kailangan talaga napakahihirap Yun lang reasonably tough, but not also a giveaway, no? Hindi giveaway ito sa mga hindi nag-aral. Pero yung mga nag-aral, masasagot yan. And so the third one that I am waiting for is there will not be any bar top notchers this time. I hope they live up with that. Masyado kasing nagiging focus na yung bar top notcher. Siguro mag-focus dapat sa eskwelahan. This will give an opportunity yung mga working students naman na who studied well, maaaring hindi nga mag-top pero you pass it on your first attempt. Napakalaking bagay na yun, no? Kasi ang hirap-hirap maging law student while working, may family ka pa, napakain. And for those working students that are watching this, si Din Bisquera po, pareho nyo. Hindi lang po working student, matanda ng working student when I took the bar examination. But I never gave up the vision and the hope of topping the bar, Sa ngayon, wala na yun. Pero no excuses that I did not top the bar. There are 1,001 reasons. And during my 2016 public interview before the Judicial and Bar Council, napakasakit naman na tinanong sa akin, bakit daw ako Bachelor Plus cum laude at valedictorian, Bachelor of Business Administration Certified Public Accountant summa cum laude in both daw my CPA board and my bar examination. Hindi naman daw mataas ang grade ko, hindi raw ako nag-top. Bakit daw? Paano niya naman sasagutin yun? Sino ba naman ang ayaw mag-top, di ba? Lalo na pag kayo panlaban ng eskwelahan nyo. Kaya lang, because of so many reasons. Ako, I will already be very direct to the point. There were certain questions, lalo na in those subjects where I felt so strong, no? Mercantile law, taxation, labor law, malalakas ang pasok ko doon. Talagang ready ako. Kaya lang kumisan, no? When the question is so has some loopholes, no? Katulad nung may binigay sa amin nung 1993 bar, may mga negotiable instruments. Tinatanong kung kumpleto raw. Kung gusto mo lang na easy answers, sabi mo, yes, complete. Nandun yung 5 requirements. Kasi cheque, yung tinakita. Yung signature doon, kaya namang ano yung stencil lagay hindi nakalagay yung printed name tapos may parenthesis signed. Kung tinunan na check yun, hindi negotiable yun because that's not a signature. And I put there, against probably most answers, I put there this is not a negotiable instrument because it was not properly signed. The name with the parenthesis SGD does not meet the qualifications of the negotiable instruments law. Siguro napikon yung examiner. I don't remember now. I didn't even bother to look at his name. Napikon yung examiner. Sabi siguro napaka-philosopher to. I'm sure tinira yung papel ko noon. No? And that's how things are. Kinakabahan niya ako kung nagalit sa akin yun. Dalawang questions yun. No? Baka binagsak pa ako noon. Kaya lang mahirap yung question sa letters of credit. Palagay ko marami naman hindi nakasagot noon. Ako naman planchadong yun. I know, letters of credit advertisement. Panuorin niyo yung aking YouTube on letters of credit and you will learn everything that you need to learn on LCs. LCs. And that was how sure meron pang isang question na hindi binigay sa bar when I took it. But again, my favorite subject under my beloved Professor Dean Celedonio Chongson, yung Renvoa Doctrine. Kasi isa yan sa pinakamahihirap na concept sa conflict of laws, no, or private international law. Pero yan, nasakyan kong kiliti niyan, no. You watch for my conflict of laws lecture on the Renvoa Doctrine. Maintindihan nyo, napakasaya, no. So with this, I'd like to thank you. And I'd like to always remind you, ang dami na po nating mga uploads. I think with this 4 uploads, siguro makakaano na tayo, mga 56. Kaya lang, parati kong nakakalimutan to ask all of you viewers, pakipirma lang ho ng konti yung yung login as a viewer. No, i-click nyo lang ho yung nakalagay dito sa ibaba. And then, at the same time, nagbibiruan sila. Pag may advertisement sa harap o kaya sa gitna, wag nyo naman cancelayin yung advertisement dahil doon daw kumukuha ng konting pang allowance namin yung Google. Okay? So, pangkonsuelo na lang sa pambili ng hopya ni Dean Bisquera. Kahit hindi nyo napanoorin yung kung hindi nyo pinapanood ng masinsinan yung advertisement, wag nyo na ma-i-cut yung advertisement. Hayaan nyo lang na to pass it on. So with this, I'd like to thank you very much. Napakamahal ko po kayo. I spend a lot of time. I have sleepless nights. Nagloloko ko minsan ng aking wifi and so on. Up to now, hindi ko pa sigurado when I can upload this. In-upload ko pa lang sa QuickTime, but when I will finally upload it sa YouTube, I will still wait for PLDT to fix up my wifi. But I am very thankful. Marami po sa inyo nagpapadala sa akin ng comment. Iba nagtatanong. Lahat po ng comment nyo I appreciate, especially those who thank me. And I get shocked when I get notes, comments as far as Cagayan Valley, as far as Butuan, as far as Zamboanga, yung aking kaibigan diyan sa University of South Luzon, si I think her nickname is Tiny or something, she's a female lawyer, law student. Kumusta po kayo diyan? Yung mga kaibigan ko po sa Cebu, kaibigan ko sa Bacolod, Iloilo. And of course, I will be very appreciative those law students na nahihiyang batiin ako who come from Metro Manila. Please do not hesitate to say, hello Dean, thank you very much Dean. Dean, kinanahan ako, or better still, tell me what you appreciated in my lectures, or if there are some things that you'd like to be clarified on. Meron mga ganon. And I always take pains to explain, my point of view. I will not claim to be the outstanding lawyer among all lawyers in the Philippines. The only thing I can tell you is I love the law. And ever since I was a little boy, I love history, I love geography. Then later on, as I move on to accounting, I love my commercial law and taxation subjects and political science. And I love every minute that I was in law school. And when I became an attorney at law, I enjoy every minute that I do my job as a lawyer. I enjoy my job as I stand up in court and say, Attorney JOE-SANTOS Balagtas BISQUERA, private prosecuting attorney, Your Honor. or for the defense, Your Honor, and all of these things. And whenever I finally get decisions that are in favor of my client, it gives me that extra feeling na siguro hahaba pang buhay ni Dean Bisquera, wala pang balak na bumigay, because I enjoy the life of a lawyer. And I will always be very happy to see young people, idealistic people who love this country, who will take up the cudgels to become members of the Philippine Bar. Marami pong salamat. I love you all, and I will always look forward that you watch all of my video YouTube uploads. Thank you very much. Mahal na mahal ko po kayo, and I will always think about you. Please pray for me always in your short prayers before you go to bed. Thank you.